Dear students, welcome to MOOC on Human Rights in India. We take up public interest litigation and prisoners' rights. Before we go further, let me outline the learning objectives for this module. You will understand what are the human rights of prisoners and how did public interest litigation advance prisoners' rights and what principles have been evolved in this process. Before we move further, let me outline the philosophy underlying the prisoners' rights. If you look at the Universal Declaration of Human Rights that was adopted in the year 1948, it asserted that all human beings are born free and equal in dignity and rights, and there are a number of articles which relate to the rights of prisoners. These find echo in the International Covenant on Civil and Political Rights. In particular, if you see Article 10 of the ICCPR, it says all persons who are deprived of their liberty shall be treated humanely and with respect to their inherent human dignity. In other words, those who are imprisoned or those prisoners shall be treated humanely. You look at Article 21 of the Constitution of India, which guarantees right to life and personal liberty. In fact, the Supreme Court of India has widened the scope of Article 21 and it has interpreted in a very progressive manner and read lot of rights which must be enjoyed by the prisoners. In fact, it's very important to remember two principles. A human being or a person doesn't cease to become a person merely by virtue of his being jailed, merely by virtue of his or her incarceration. He continues to enjoy a number of human rights, including right to life, right to food, right to health, and only doesn't enjoy the right to liberty, freedom of movement, which are curtailed by an order of the court of law. But he still continues to be a human being and enjoys certain rights. The second principle is that a person is sent to prison as punishment and not for punishment. In other words, nobody can inflict third degree or inhuman treatment upon a prisoner. So these are very important principles which have to be kept in mind while dealing with the prisoners' rights. Over a course of the last few decades, a number of public interest petitions came before the Supreme Court of India from prisoners or from the concerned or affected individuals or from non-governmental organizations. Now let me take up a few of them to illustrate certain aspects. For instance, let's see the compensatory jurisprudence evolved by the Supreme Court of India. There is a Neelabati Behera versus State of Orissa, which was decided in the year 1993. Here was a case of a public interest litigation where a 22-year-old boy died in the custody of police, and his mother wrote a letter to the Supreme Court and it was taken up as a public interest litigation. Here, the Supreme Court evolved a principle of public law doctrine of compensation for violation of human rights. In other words, for violation of human rights, state is liable for payment of compensation. And there have been other cases. In fact, in this particular case, the Supreme Court ordered that a sum of rupees 1,50,000 be paid to the mother of Neelabati Behera. Let me turn your attention to the inhuman treatment of prisoners. In fact, as I told you, that a person is sent to prison as punishment and not for punishment. In the case of Kishore Singh versus state of Rajasthan, the Supreme Court came down on the use of third degree methods and held that it is a violative of the constitutional guarantee given in the Article 21 dealing with right to life and personal liberty. In fact, it asked the government to educate police personnel and see that they develop a respect for the human person. In fact, this has been reiterated, followed in many other cases over the years. In D.K. Basu versus State of West Bengal, which is again a very important landmark case, the Supreme Court of India treated a letter from the chairman of the West Bengal Legal Aid Services Authority, drawing its attention to the increasing instances of custodial deaths in the state of West Bengal, and the Supreme Court gave detailed guidelines to all the states explaining what needs to be done when somebody is arrested and how a near relative must be informed and what kind of facilities shall be given to the persons who are arrested, including provision of medical aid, medical examination at the time of arrest and subsequent periodic intervals. And the Supreme Court also said the rights of these people who are arrested shall be displayed prominently in police stations for the information of everyone. In this case, the Supreme Court very clearly affirmed that the law doesn't permit use of third degree or torture on the accused persons in custody and either during interrogation or during investigation. There is a famous quotation which the court said, custodial torture is a violation of human dignity, and whenever human dignity is wounded, the civilization takes a step backward and the flag of humanity shall fly half-mast. Very profound statement from the Supreme Court, and the Supreme Court also said any violation of these guidelines will be deemed as contempt of the court. Now let us turn our attention to another important aspect, namely solitary confinement and the use of bar fetters. In the case of Sunil Batra 1, in fact he took a number of petitions before the Supreme Court, and in what is known as Sunil Batra 1 versus Delhi administration, the court went into details of the use of solitary confinement and bar fetters, and also decided on the constitutional validity of these provisions which are there in the Prisons Act. In fact, there was an argument that a person who is under the death sentence shall be held in solitary confinement as per the provisions of the Prison Act. The court said the sentence of death which is mentioned there must be final executable death sentence and not an interim stage. So the court made a very important distinction and held that solitary confinement of Sunil Batra was illegal, as his sentence was not a finally conclusive executable death sentence. And the court also went into the use of bar fetters, again provided in the Prisons Act, and gave a series of guidelines on reducing the rigor of the use of bar fetters. We have seen the solitary confinement and the use of bar fetters. Let us now focus our attention on the handcuffing often resorted to by the police. In fact, there was a public interest litigation which challenged the constitutional validity of handcuffing culture. In Prem Shankar versus Delhi administration, the Supreme Court banned routine handcuffing resorted to by police at that point of time, holding that it is a inhuman, unreasonable, harsh and arbitrary, and the court held that it violated Article 21 of the Constitution, which guaranteed right to life and personal liberty. The Supreme Court also said if any police officer violates its guidelines on handcuffing, that person will be personally liable to pay compensation, and this principle was laid down in the state of Maharashtra versus Ravikant Patil. Now, let us take one more aspect of prisoners' rights, namely right to have interview with friends, relatives and lawyers. In Francis Corali Mullin versus Administrator of the Union Territory of Delhi, the court observed that this right to have meetings with friends, relatives, etc. is a part of right to socialize, and which is again a part of the right to personal liberty, which is mentioned in Article 21 of the Constitution, subject to prison regulations, if any. And the court also said these prison regulations which restrict the prisoners' right to have meetings with friends, relatives or lawyer must be reasonable and not arbitrary. In Joginder Kumar versus State of Uttar Pradesh, the court again reiterated the right of a person who is arrested to legal representation, access to a lawyer, and whenever such an arrest happens, a relative or a known person should be informed about such an arrest. Now let us turn our attention to right to legal aid. In Hussain-Ara cartoon versus Home Secretary State of Bihar, the Supreme Court held that right to legal aid is an important constituent of right to speedy trial, and which is again covered under Article 21 of the Constitution of India, dealing with right to life and personal liberty. And the Supreme Court asked the state to ensure that legal aid is made available to all deserving cases and all deserving persons, so that a right to speedy trial itself becomes a very important reality. Insofar as right to speedy trial is concerned, there were several other judgments of the Supreme Court of India highlighting the need to ensure right to speedy trial. In particular, Y.S.R. Antule versus R.S. Nayak case, the Supreme Court said this speedy trial shall be afforded to persons at all stages, including investigation, inquiry, trial, appeal, revision, etc. In Common Cause versus Union of India, the Supreme Court again held that right to speedy trial is a part of the constitutional guarantee dealing with right to life under Article 21 of the Constitution of India. Let us turn our attention to the use of narco analysis or polygraph test or brain mapping, often resorted to by the investigative agencies in some highly complicated cases. In Selvi versus State of Karnataka, the Supreme Court held narco analysis, brain mapping or polygraph tests as unconstitutional. In fact, the court said that there should be fair consent, informed consent of the person who is subjected to these procedures. The court in particular drew attention to the Article 20, subclause 3 of the Constitution of India, which prohibited testimonial compulsion. Basically, no one can be compelled to act as a witness against one's own self. So, having regard to all these, the Supreme Court observed that the National Human Rights Commission's guidelines on the use of such tests shall be followed and subject to the informed consent. If you look at this range of cases which have been decided by the Supreme Court of India, we find that the guarantee provided under Article 21 has been widened, has been interpreted in an expansive manner to breathe life into the prisoner's rights, and the court in fact reduced the rigor of a number of provisions and to ensure that the inherent dignity of the human person and particularly the prisoners is guaranteed and protected and promoted.